LD 1609, an act to stop social media censorship. The bill is presented by Representative Sampson. Representative Sampson, welcome back to the Judiciary Committee. It's good to see you again. Please begin your presentation as soon as you're comfortable.
Thank you, Representative Harnett. Nice to see you too. And greetings to the members of the Committee on the Judiciary. I am Heidi Sampson, representing the good people of House District 21. That's Alfred, Limerick, Shapley, Newfield, and Parsonsfield. I am pleased to introduce LD 1609, an act to stop social media censorship. This proposal to stop social media censorship act creates a private right of action that allows citizens of this state to bring against the major social media websites that have more than 75 million subscribers that were never affiliated with any religious or political group from their inception, that censored the users of religious and political reasons for religious and political reasons. To be specific, this act applies to the social media websites such as Facebook, Twitter, and YouTube. Currently, when a social media website censors a user for religious or political reasons, the victim can sue the social media website for an existing form of breach, bad faith, unfair dealing, unjust enrichment, and false advertising. The act gives teeth to an existing form of actionable conduct that makes litigation realistic. Leading up to the introduction of this bill, the problem has been that it has been difficult for victims of censorship or the courts to determine how to calculate damage when a social media website deletes a profile for arbitrary reasons. This act allows the victim to seek statutory damages of $75,000 on top of the other forms of damage. So there has been some guarantee of recovery, making it realistic that victims will hold the social media website accountable. This bill also allows the victim to seek attorney fees and costs. This will incentivize local lawyers to take on these cases. This bill will strengthen the bar and the law economy while deterring social media censorship by leveling the playing field. $75,000 is the jurisdictional minimum to get an injured party into federal district court under diversity jurisdiction. None of these social media websites engaged in censoring the public, none of them reside in Maine. Therefore, the matters would need to be litigated in federal court. It is my understanding that states have a paramount jurisdiction over contract law issues. When someone in Maine signs up to use a social media website, they enter into a contract. Therefore, Maine can set some parameters around those contracts and hold certain actors to high standards that have been prone to bad acts without accountability. When a citizen of our state is censored, the courts in this state could have paramount jurisdiction over the controversy under the long-arm statute. The free exercise clause of the First Amendment is the underlying federal constitutional legal basis for this bill. Therefore, we in the state of Maine are able to introduce policy language to treat major social media websites as we treat public utilities. However, to create a private right of action would likely be a better first step towards the solution of this problem. Basically, the major social media websites have knowingly created a digital public square. Maine has a compelling interest to ensure its citizens are permitted to speak their religious and political opinions in any form of quasi-public square. This act will better allow the citizens of Maine, regardless of political or religious persuasion, to share their views by holding major social media websites to higher standards of care through carving out a special cause of action. It is vital to mention the few exceptions and exemptions that go with this act. The social media website can censor certain speech such as pornography, accounts that are falsely impersonating, or speech that calls for immediate acts of violence. I thank you for your consideration and your attention.
Thank you very much, Representative Sampson, and thank you for bringing this bill forward to the Judiciary Committee. I will now turn it over to questions for committee members, beginning with Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Representative Sampson. I wonder if you could enlighten our committee. I personally know of dozens of people who were censored on Facebook over the last 6 months. Accounts locked down and they were not allowed to post or comment. And I wonder if that has been a common experience. Have you had any firsthand knowledge of similar experiences in your acquaintance?
Yeah, thank you for that question. And actually, that was one of the reasons why I wanted to bring this bill forward. And I actually have had numerous people reach out to me, and some of the most unsuspecting. I mean, in all cases, they were unsuspecting victims who weren't doing anything provocative. And I can think of, in particular, the one that stands out to me the most is this young mother. She maybe had a couple of hundred followers on her Facebook page. And really, she doesn't even know what the reason was. All of a sudden, her entire account was gone, just gone. And she was extremely upset because that meant all the pictures. She just had a baby. There were all these pictures of the baby and their wedding. And so all of those just disappeared overnight. And with who do you reach out to? Who do you ask the questions of? And what was the reason for it disappearing? And hers was probably the most outrageous because she's just a young girl, new mom, hardly anyone even on her Facebook page. It wasn't like there was this massive movement, nothing like that. And I've had numerous examples of people on so many different issues that just their Facebook page was completely shut down. As members of the legislature, I've been able to try and restate some of those through some of our contacts that we are privileged to as legislators, but not all of them were successful. And so it just seemed like such an egregious and really it's very unfair. It's unfair. It's not allowing, certain people are allowed to say whatever they want to say, and somebody else doesn't even know what they said and they get shut down. So it's not a level playing field by any stretch of the imagination. And it seems to be an increasing thing. We're seeing this increasingly, but this isn't just talking about big names. These are talking about everyday citizens, my constituents and friends around the state of Maine. And so hopefully that answers your question.
It does. If I could ask a quick follow-up, Mr. Chair?
Yes, you may, Representative Libby.
Do you believe, or does your constituent believe that the actions on the on the part of the social media platform went against her First Amendment rights?
Oh, without question. It shut it down completely without any warning. That's the other thing. No warning, no explanation. It was completely removed.
Thank you.
And there were other cases, but hers just seems so absolutely insane.
Thank you very much.
Thank you, Representative Libby, and thank you for your responses, Representative Sampson. Representative Moriarty.
Thank you, Mr. Chair. Good afternoon, Representative Sampson. Obviously, as we all know, every bill has a sponsor. And frequently this session, we've had public hearings and sponsors have come forward to present their bills, and yet at the same time have frankly acknowledged to us that they really are not acting on their own, but are acting on behalf of some other organization. It may be governmental, it may be private, It may be on behalf of a person or one thing or the other. And then they have deferred to that person, organization, or governmental entity to kind of carry the water, so to speak. So my question to you is, if you can answer for us, whether this bill has been presented on behalf of or at the request of some other organization or individual.
Well, that's an interesting question, and I'm happy to answer that. Because as I already said, this was an issue that I already had a problem with in my district and folks around the state who had reached out to me. And so I was looking for language that I could use to introduce. And so, yes, so there's a gentleman who is an attorney who has been litigating some of these cases on a federal level, who is prepared to speak to this bill. But to imply that I brought something forward because someone asked me, sir, you don't know me. So I have very clearly, I have asked to submit this bill. And this is something that I hold as very important and something that absolutely needs to be addressed.
Okay, well, that's fine. But as I said, many people have come forward and said, I've been asked by so-and-so to present this bill, myself included.
I can honestly say I was not asked. I asked myself.
That's the answer to the question. Thank you.
Thank you.
Thank you, Representative Moriarty. Thank you for your response. Representative Sampson, Representative Evangelos.
Thank you, Mr. Chair. Good afternoon, Representative Sampson. One of the concerns I have with the bill is, and I understand your concern and things of that nature, but the part about having the Attorney General be the lawyer for these people who feel they've been disaffected, don't you think that's sort of a dangerous precedent and slippery slope? It could be that the Attorney General's office is going to be getting awful busy.
Well, that's a possibility. But honestly, Representative Evangelos, you know as well as I know, once a bill is in the committee's hands, a committee can do what they choose to do with that bill. So it's a suggestion and worth considering. And so I'm not really sure how else to answer that, except what would you suggest? And you're on this committee.
Well, I mean, the other alternative in these sorts of cases is the people obtain legal counsel.
Well, like I said, as a member of the judiciary with this bill in your jurisdiction, you would have the liberty to amend the bill as you choose to do so.
Thank you.
Thank you, Representative Evangelos. Thank you, Representative Sampson. Representative Thorne.
Thank you, Mr. Chair. And to Representative Evangelos's point, I'm just reading through when it addresses in the bill the Attorney General. Line 27 on page 2. The Attorney General may bring, and then on page 3, line 13, a social media website user or the Attorney General may bring an action. I don't see anything that requires the Attorney General's involvement, just that it allows.
Correct.
Did I miss something in your statement?
It is, they may.
May. Okay, thank you.
Thank you, Representative Thorne. Representative Poirier.
Thank you, Mr. Chair, and welcome, Representative Sampson. Good to see you. My question is, in the crafting of this bill, did you look to other states and have other states, in fact, pass similar legislation?
Well, I know there's other states that have submitted similar language, and I'm not going to speak to that as much as the gentleman who is going to follow me can speak to that, because he's been working in those states.
Thank you.
Thank you, Representative Poirier. Are there additional questions for the bill sponsor, Representative Sampson? Seeing none, again, thank you very much for bringing the bill forward, and thank you for taking the time to testify before the committee today. As the bill sponsor, you are welcome to stay as a panelist for the remainder of the public hearing if you so choose.
I appreciate it. Thank you.
You're very welcome. I will next turn to persons who have registered to testify in support of LD 1609 and ask for Christopher Sevier to be moved into the room as a panelist. And I would remind people, as I will do all afternoon, other than the bill's sponsor, all persons testifying will be limited to a 3-minute time clock. With 20 seconds left, I will hold up a yellow Post-it and then put that down. And then at the end of 3 minutes, I will hold up a red folder that indicates that your time is up. So at this point, I would recognize Mr. Sevier. Mr. Sevier, welcome back to the Judiciary Committee. Whenever you are comfortable, please begin your 3-minute testimony.
Thank you, Mr. Chairman and Madam Chairman, distinguished members of the Judiciary Committee. I'm going to talk very quickly. Feel free to ask me any questions you want. Chris Sevier from De facto Attorneys General. There's 29 states moving on this. Three of the states, the prime sponsors, are Democrats. This is a bill that's designed to protect your constituents. That's what this is about. I'm coming to you as an officer of the federal district court to say that the solution here does not need to be a federal one, doesn't need to be a judicial one. We need the state legislatures to enact this bill in all the states because of this reason. This is a key point. The bill was written to fall within what's called the state law exemption of Section 230 of the Communications Decency Act. It's subsection E, subparagraph 3. So what does that mean? What is Section 230? It's a statute passed in the 1990s by the federal Congress that allows internet intermediaries to invoke a defense if they get sued for the acts of third parties. So that's still confusing. What does that mean? So the best way to understand it is through an example. If someone posts a defamatory comment on YouTube, the defamed individual can sue the person who defamed them. But if they named YouTube in that litigation, YouTube could invoke a Section 230 immunity defense and be dismissed from the case. So we think Section 230 is good law. However, what's been happening now to your constituents is that when they get censored, Democrat and Republican both, if they try to take recourse, the tech companies invoke Section 230 immunity defenses in litigation. This bill is written to fall within an exemption that was carved out by Congress that allows the states to pass a bill so that you can protect your constituents. And that's what this bill will allow. If you bring a lawsuit, an individual or the Attorney General brings a lawsuit pursuant to this statute, then when the tech companies invoke a Section 230 immunity defense, it will cut through it and it won't work. So that's why this bill is a bipartisan matter that we really need the states to provide a solution to. Okay, so that's point one. I got 3 other points. I'm going to try to get them in. Point 2 would be, what does this bill say? It says going forward in the state, if a social media website that has more than 75 million subscribers that was never affiliated with a religious or political party from their inception, if they contract with a constituent in your district and they turn around and censor them for their religious or political beliefs, you guys will be giving them power where they will be able to bring a lawsuit pursuant to the statute in civil court, where they can file in federal court or state court. They have choice of venue, where they can seek up to $75,000 in statutory damages, attorney's fees, costs, and other forms of equitable relief. And that is going to crush social media censorship. Contract law is a state law issue. When a member of your district signs up for Facebook, Twitter, YouTube, they're entering into a contract. You guys have jurisdiction to regulate here. It's an adhesion contract, but it's still a contract, so it gives you jurisdiction. But the courts look at mainly how they market themselves in terms of whether, enforceability. They're not going to really enforce the contract. They're going to look at how they market themselves. This is a key point. When a person in your district signs up for a social media website and they get censored, That's an existing form of breach of contract, bad faith, unfair dealing, fraudulent inducement, false advertising. This is deceptive trade practice. This is deceptive trade practice. All this is what this is. And so those are not forms of First Amendment protected speech. They're not protected under the First Amendment. And I've got two other points, but Mr. Chairman, I might be out of time.
You are, sir.
Yes.
The 3 minutes has expired, and I forgot to mention that all persons testifying should open by letting the committee know their town of residence.
Yes, sir. Well, I'm working in 37 states. I'm in Hollywood, California today, but when I'm in Maine and I'm working with different assets there, whether we're fighting human trafficking, I'm working out of Augusta.
Your town of residence, where you reside.
New York City is where I live most of the time when I'm not. Yeah.
Thank you, sir. I will now open it up to questions from committee members. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Sevier. This is a new area for me, so I would appreciate hearing your final 2 points, if you could, please.
Can I make before responding to that, I'd like to make a request to committee members. We have a 3-minute clock for a reason. We have 170 bills that we are working. We give each person 3 minutes to provide testimony other than the sponsor, and we then open it for clarifying questions. If the question is, could you please repeat your testimony? We conclude your testimony. We no longer have a 3-minute clock. So I would ask that you pose it as a question, Representative Libby.
I certainly can do that. I can get very specific. So my question at the moment is, what is the underlying constitutional legal basis for this bill?
So this was the point I was going to try to address. So basically, the opponents of this bill are going to say this bill violates the First Amendment in some general, vague way, but they won't explain how. And they're going to act in their own interest, and they're not going to care about your constituents. Okay. The First Amendment of the United States Constitution, as well as the Maine Constitution, does not apply to private actors. It applies to the government. It limits the government from engaging in action that encroaches on free speech. But bad faith, unfair dealing, false advertising, deceptive trade practice, those are not protected forms of speech. So the First Amendment does not protect them. The First Amendment, while it's a restraint on government, it's restraint on the state legislature, it's also like a trampoline. It's a catalyst where it gives you the power to act through it so that you can protect your constituents from consumer protection violations. This is a very straightforward consumer protection bill that Representative Heidi Sampson is the prime sponsor of, that she's put together. And so again, the First Amendment is the underlying federal constitutional legal basis. Any argument floated by opposition is going to manipulate that, and they're going to distort that. And there's no way to get around the fact that this bill is written to fall within the state law exemption under Section 230 of the Communications Decency Act. So it's not preempted by the federal doctrine of preemption, nor is it preempted by the First Amendment. In fact, the First Amendment is the catalyst by which you guys can act to protect your constituents on a bipartisan matter. This is above politics. This is a very serious problem that's hurting constituents all around Maine.
Thank you.
Follow up, if I may, Mr. Chair?
Yes, sir.
Yes, you may, Representative Libby.
Thank you. So I have heard it suggested that if folks don't like the censorship, they can just get out and do their own thing. So can you explain, I know that there was a lot of brouhaha around Parler recently. So can you please explain why that's not really a tenable option?
Yes, Representative. There's different forms of objections to any bill. One would be, some sides say the First Amendment, and I'll explain that. The other side is, well, if you don't like Facebook or Twitter and you live in Maine, why don't you go out and form your own Facebook, Twitter, or YouTube? And the reason why that proposed solution is untenable as a matter of law is because Facebook, Twitter, and YouTube have reached what's called critical mass. They have billions of subscribers. Hundreds of thousands of people in Maine or have a user profile on these accounts. And, what they've done is they've accomplished that through fraud. They've promised your constituents that they can sign up, they can post their pictures, they can express themselves, only to then turn around and censor them if the speech offends the delicate sensibilities of the employees who just happen to work at those social media websites for that day. So it's not, from a legal perspective, the idea of, well, you can just go out and form your own thing and allow us to get away with false advertising and fraudulent inducement. That's an untenable legal solution. Again, I'm going to keep saying this, and that is the solution. There's not many solutions to this. We can't repeal Section 230. That would have bad secondary effects. the courts have been looking for a solution, and it is our impression as federal litigators that the courts are suggesting and indicating and tipping their hat to say they need the state legislatures, whether they're blue or red, to enact this statute. It falls within the state law exemption. The bill is designed to parallel the spirit of Section 230. It doesn't conflict with it. It parallels it. The Communications Decency Act was designed to promote decent speech. It was designed to fight pornography, really. It was never designed to be used as an excuse to enable deceptive trade practices, which are practices that are injurious to your constituents.
And I do have one more follow-up, Mr. Chair. I'm happy to defer if anyone else would like to ask any questions, and you can come back to me.
I will do that, Representative Libby. Representative Newell.
Thank you, Mr. Chair. I would just ask, Mr. Chair, if we can move on with the next individual here to testify.
Thank you, Representative Newell. I will allow one follow-up question from Representative Libby, a clarifying question about the testimony.
Yes, thank you. You said something briefly, Mr. Sevier, about exemptions, and you specifically mentioned pornography. So would this bill still allow for the social media platforms to not allow certain actions if they are not legal?
Yeah, absolutely. So, in working with Democrats like Senator Gabbard, Tulsi Gabbard's father, who's the prime sponsor of this in Hawaii, or Representative Wilkinson from Rhode Island, who's a prime sponsor, or the sponsors from New York, or Democrat sponsors out of the country, we have sat down with tech together in a bipartisan, mature manner to determine what should those exemptions.
Mr. Sevier, I believe you answered the question when you said yes.
I did not answer the question, sir.
She asked a yes or no question, and you answered it yes.
I don't even, Mr. Chairman, I mean, if you want me to help you, I'm glad to help you. But if you,
I understand that, sir, but we have a slew of bills in front of us today. She asked a yes or no question. You answered it yes. Representative Libby.
I would like to make the point of order that this witness is for the second time on a second bill being treated in a hostile manner that I have not seen on any other bills. He is not being antagonistic or inappropriate, and I would like to see him be able to give full answers. I have not seen this on a single Democrat bill, and I would like Representative Sampson's bill to have the full hearing that it deserves, and that means having all of our questions answered.
But
Thank you.
You asked a yes or no question, and he answered yes, and then went on into a speech. We're not here for speeches. We're here to ask clarifying questions to persons presenting testimony. Well, if you have a question to ask, you may ask the question, but we cannot have the questions answered with speeches.
I appreciate that, Mr. Chair, and I will be sure in the future to call a point of order anytime someone expounds beyond a simple yes or no for a yes or no question. Thank you.
Thank you. Are there additional questions from committee members? Seeing none, thank you very much for your testimony today, Mr. Sevier. We appreciate you taking time out of your day.
Yes, sir.
Looking at persons who have registered to testify, I do not see anyone else registered to testify in support of LD 1609, but I will check the attendee room to make sure that there is not somebody who wants to testify in favor who did not have the opportunity to register. If you want to testify in favor of LD 1609, please raise your electronic hand. Seeing none, I will now turn to those testifying in opposition to LD 1609 and call upon Carl, I hope I'm saying your name right, Sabo.
Spot on, Mr. Chairman. Thank you very much.
And I would just remind you, sir, as I remind all witnesses, we have a 3-minute clock, and please start by letting us know your residence. Thank you.
Will do. My name is Carl Szabo. I'm Vice President and General Counsel of NetChoice. I'm also adjunct professor at the George Mason Law School. My residence is Rockville, Maryland. Thank you for the time this afternoon. I've been addressing these issues across the country. I myself am a conservative, but I am opposed to LD 1609. Why? Because it violates the First Amendment and conservative principles that private businesses should be able to do what they want. Now, one of the things that's important to note is there's a lot of lawful but awful speech out there that would be allowed under this legislation. Political speech does include terrorist recruitment speech. It's their political views that America should be destroyed. It would it would prevent platforms from removing people saying the Sandy Hook shooting was a good thing, as long as it's done in a political context. Spam prevention by email couldn't be done if somehow they slip in something political or religious in nature. For example, Jesus wants you to buy my products. Can't block those spam emails. What if Etsy doesn't want to sell a swastika? That's a political symbol. That's political speech. This bill would force them to provide that type of content. That's the type of lawful but awful content that this bill would authorize and force platforms to keep up. Now, another question was on the First Amendment. Well, this is clearly unconstitutional. It's not just my opinion. Many of the largest law firms in the world have done legal briefs analyzing it. When the law was passed by the legislature of Utah, Governor Cox vetoed it on First Amendment grounds, and a number of cases from the Supreme Court. I'll just name a couple: Miami Herald versus Tornillo, Turner Broadcasting versus FCC, Reno versus ACLU, Brown versus Entertainment Merchants Association, and National Institute of Family Life Advocates versus Becerra, all hold that the state cannot compel a private business to host speech or say something it doesn't want to say. This would be unimaginable if the government said that the Portland Press Herald had to host speech or do an op-ed or host an op-ed that it didn't like because the op-ed was political or religious in nature. But somehow, if you're an online platform, you do have to. Now, I did hear Mr. Sevier complain that platforms have been deceptive or fraudulent. Well, the good news is that you don't need this legislation. If any business is engaged in unfair or deceptive trade practices, your state AG can take an enforcement action today under existing state and federal law. And 3 minutes are up, so I will stop there and welcome any questions or comments you may have. Thank you.
Thank you very much for your testimony and for being right on the money in terms of time. Are there questions for Mr. Sabo? The first hand I saw was Representative Thorne, followed by Representative Libby.
Thank you, Mr. Chair. Mr. Sabo, I missed at the beginning who you represent.
I represent NetChoice. We're a trade association that promotes free expression and free enterprise.
Okay, thank you. And a follow-up, if I may, Mr. Chair?
Yes, you may, Representative Thorne.
Mr. Sabo, did you show up today and testify on your own accord, or did somebody ask you to testify today?
I testified on my own accord. I mean, I represent NetChoice, but to the extent that anyone told me, no, it's because I'm here and it's because I represent NetChoice.
You showed up because you, on your own accord, nobody requested that you show up and represent NetChoice.
No, I'm here on behalf of NetChoice, but I also believe what I say. So I believe, and I will vehemently...
Mr. Chair, may I reform the question?
I'm not, he said he represents an entity.
I just wanted to pose it in a yes or no question.
Absolutely.
Mr. Sabo, are you here today on your own accord?
Yes.
Thank you.
Thank you, Representative Thorne. Representative Libby.
Thank you, Mr. Chair. Mr. Szabo, first of all, I must have missed it. I was absent for a quick moment. You must have already said where you reside.
Rockville, Maryland.
Yes, Rockville, Maryland.
Thank you. My question is, you mentioned the Press Herald, and thank you for bringing that up. It's my understanding that the Press Herald is a publishing entity that directs and edits what they put out. Are you comparing Facebook to that? Does Facebook direct and edit what they put out as a publishing entity?
Ma'am, they are not a publishing entity. However, that is only applicable to the extent that we talk about Section 230. I did not mention Section 230 at all in my testimony. All I spoke about is the violations of the First Amendment, which, just like the Herald, Facebook is a private business, and the state cannot compel a private business to host content it does not wish to host.
I appreciate that. My specific question is Facebook a publishing entity like the Press Herald? I guess that's a yes or no question.
They are not a publishing entity like the Press Herald.
Thank you.
Are there additional questions from committee members for Mr. Szabo? Seeing none, thank you very much for your time and testimony today, sir, and taking time out of your day to present it.
Thank you very much.
The next person that I have registered to testify against LD 1609 is John Olson. I would ask for Mr. Olson to be moved over to the panelist status. Mr. Olson, welcome to the Judiciary Committee. As you've heard me say to others, I will start a 3-minute clock when you begin testifying, and please let us know your place of residence at the outset of your testimony. Welcome, and begin when you're comfortable.
Thank you, Chair Hartnett and members of the committee. As you mentioned, my name is John Olson. I am the Northeast Director of the Internet Association, IA, and I reside in Albany, New York. IA is the only trade association that exclusively represents leading global internet companies on matters of public policy. Our mission is to foster innovation, promote economic growth, and empower people through the free and open internet. We believe the internet creates unprecedented benefits for society. As the voice of the world's leading internet companies, IA works to ensure legislators, consumers, and other stakeholders understand these benefits. IA respectfully opposes LD 1609, which would create actionable claims when privately owned internet platforms exercise their First Amendment right to remove harmful content. While IA shares the author's interest in promoting diverse online discourse, this legislation would prevent service providers from taking critical actions for the safety of their users. Despite the characterization of social media platforms as digital public squares, the fact remains these forums are still controlled by private entities. Section 230 of the Communications Decency Act prohibits liability in cases of content moderation. Without Section 230, the law could treat a provider who turns a blind eye to harmful content more favorably than a platform that takes action to try to protect consumers. With its passage of the law in 1996, Congress made it clear its intent that Section 230 should empower providers to engage in content moderation. To realize the full benefits of online services, it is critical that service providers are able to set and enforce robust rules designed to protect the quality and integrity of their services. Today, providers regularly act against spam, malware and viruses, child sexual abuse material, scams, threats and harassment, impersonation, non-consensual intimate images, and other content that, regardless of whether illegal or legal, is harmful to the users of their services and the public at large. LD 1609 would put the safety measures providers take daily at risk by seeking to limit the scope of enforcement that can be undertaken without the threat of litigation. Consumers will not benefit from this. Further, LD 1609 would put online companies in the position of defending content moderation decisions in a court of law. Regardless of whether a platform was acting appropriately under the bill, individual users would still be empowered to sue and take the company to court to challenge content decisions. This would be an untenable solution, leading either to more curated internet, where less diverse voices can be heard, or a return to a lawless internet, where harmful content overwhelms the healthy discourse and exchange of ideas that we all desire. For these reasons, I strongly urge the committee not to advance LD 1609. Thank you for your time, and I will happily take any questions.
Thank you very much, Mr. Olson, for your time and testimony today and for presenting it to the Judiciary Committee. Representative Libby.
Thank you, Mr. Chair, and thank you for being here today, Mr. Olson. A couple questions. One is, you mentioned harmful content early on in your testimony, and I'm a little bit curious about how that is defined exactly. I'll give you an example. I, at one point, had an acquaintance who was not allowed to post on Facebook for 30 days over this past winter because of posting up a political meme. There was nothing sexual about it. There were no swear words. There was nothing that I think your average person would think was inappropriate. At the same time, multiple other friends had complained to Facebook because there was a suicide of an acquaintance that was still live on the website for quite some time. So I'm just curious about how that harmful content is defined. These seem like pretty clear. One seems pretty harmful while the other does not. So I'm just curious if you could expound on that a little bit. What exactly is harmful content?
Well, I think harmful content is defined differently between platforms and is found in their user guidelines. I can't expound accurately on what it actually is defined as in each user guideline. What I will say is, in the cases you represent, that most likely the content moderators did not actually get to the video in question, but either an algorithm or for whatever reason, whatever timeline this meme was posted in, it may have been boosted to the front based on whatever activity was happening on a national level. So, with respect to political memes or any other content that may be in so-called gray area, it really is just the exercising of the private entity in determining that content needs to be removed.
I have another question, Mr. Chair.
Yes, you may, Representative Libby, go ahead.
Thank you. So my question is, are breach of contract, bad faith, unfair dealing, deceptive trade practice, false advertising, and fraud protected forms of speech for purposes of the First Amendment?
I don't think so, but that is not what we're referring to in this bill.
Thank you.
The representation of breach of contract is not the same as a private entity exercising its First Amendment right to remove content.
Representative Thorne.
Thank you, Mr. Chair. Mr. Olson, have you read the exemptions?
Of the bill?
Yes.
Yes.
And do you find those to be acceptable?
I find the bill to be unacceptable in general.
I meant the exemptions per se.
They are a good start, I would say, but the entire bill has severe issues with the First Amendment and Section 230 of the Federal Communications Decency Act.
Okay. Follow-up question, if I may, Mr. Chair.
You may, Representative Thorne.
Thank you. The bill is an act to stop social media censorship. You said you're the Northeast Director of the Internet Association?
That's correct.
What's your definition of censorship?
I'm not a legal attorney. I don't want to start defining things. My idea is irrelevant to this. Censorship is not the issue with this bill. The bill is compelling private entities to cease removing content based on a certain point of view. Censorship is not an issue with a social media platform. If the government were to compel a company to censor certain people, that would be an issue of censorship.
Were you aware that the title of the bill is an act to stop social media censorship?
Yes, I'm fully aware of the intent
but you don't know
the bill.
But you don't know what the definition of censorship is. Okay, thank you, Mr. Chair.
Thank you, Representative Thorne. Are there additional questions for Mr. Olson? Seeing none, thank you very much for your time and testimony today and taking the time to present it to the committee.
Thank you, Chairman.
That is all the persons that I have signed up to testify in opposition to LD 1609. But I will go to the attendee room to make sure that I'm not missing anyone. Are there any persons in the attendee room who wish to testify in opposition to 1609? If so, please raise your electronic hand. And seeing none, I do have one person who is signed up to testify neither for nor against. So I would ask the committee clerk to please move over Samantha Fillmore from the Heartland Institute. And welcome, Ms. Fillmore. As soon as you are comfortable, activate your mic and camera, and please begin your 3-minute testimony, and welcome to the Judiciary Committee.
Hi, thank you, Chairman and members of the committee. My name is Samantha Fillmore. I am the State Government Relations Manager at the Heartland Institute, which is based out of Chicago, Illinois. That's where my town of residence is. We are a national nonprofit think tank, This year, we have seen and worked on 59 pieces of legislation in 29 states, all attempting to challenge big tech in some way and asking all of the same questions that you are. How can we protect our constituents and also deal with this very lofty constitutional issue? However, I would like to point out that the volume of the bills across the nation through this legislative session is indicative of the fact that so many lawmakers and constituents and Americans are realizing that we're entering into a potentially dangerous time for free speech in our society. These tech platforms have become omnipresent with all political speech and expression, and yet we see these companies sometimes flippantly deciding to take things off, as some of the representatives today have mentioned examples of. Opponents of this legislation would argue that censorship is appropriate because market forces have allowed these titans to rise to power. And to that, I would submit to you that these instances are not a product of a healthy free market, but rather the result of a corrupted market based on the liability, gifts, and protections provided to these companies through the Federal Communications Decency Act. Big tech enjoys monopoly-like protections from the federal government, and this legislation would begin to fix the corruption in that market for your constituents. 72% of the United States population used social media in 2020, and ad revenue for these companies reached $40 billion in 2020. So this is not a small or insignificant issue. According to a Pew Research study, 70% of, or three-quarters of United States adults feel that big tech intentionally censors political speech based on viewpoints that they may objectively deem objectionable. So this bill would send the message to your constituents that you are concerned about protecting their First Amendment rights and that public speech is sacred in your state. Finally, I would like to submit to you that on the issue of freedom of speech, more speech is always a solution, not less. And again, I've been working on all these states, 29 states while moving through this. If you have any questions for me, I would happily answer them, but I also don't want to take up any more of your time. So thank you, committee and chairman, for your time today.
Thank you very much, Ms. Fillmore, and thank you for presenting your testimony in 2 minutes and 30 seconds. Greatly appreciated. Are there questions for Ms. Fillmore? Representative Libby.
Thank you, Mr. Chair, and thank you for being here, Ms. Fillmore. I'm interested, you mentioned so many other states that you've seen this legislation or worked on this legislation. Are there any states where similar or same legislation has been passed? I know we're just in the public hearing part of this process, and I'm curious to know what is going on in other states.
Absolutely. So this is a brand new issue that all of these bills came up very quickly, right in the beginning of the year. So it has not a single bill has been signed by the governor yet, by any state governors yet, but we have gotten them through both houses in a number of states, including Texas and Florida, namely. So especially in Florida, we are just one step away. We're waiting. It's on DeSantis' desk at some point. So we're definitely working it through all of the stages, through all of, as you know, the many committee meetings and many House votes and everything else. But nothing has officially turned into law as of yet. It is still only May, though, as you know.
Thank you very much.
Thank you.
Thank you, Representative Libby. Are there additional questions for Ms. Fillmore? Senator Keim.
Thank you, Mr. Chair. I'm sorry that I won't be able to turn on my video at this time, but I did have one question for Ms. Fillmore, which was one of my great concerns around this topic is the idea of the monopoly that's happened with the large tech, and now they've all combined with one another. And so then essentially their policies can cancel out what we've all come to expect. And I just wondered if you could speak to the idea around a monopoly. You know, I am looking for solutions, and your seem to be a voice that might be able to help offer some opinions on that. Thank you.
Thank you, Senator Keim. Yes, so I mean, as we all know, it is no secret that the federal government in recent years has had many congressional hearings.
Ms. Fillmore, could you move a little closer to your microphone? I know I'm having difficulty hearing.
I'm sorry, is this better, Chairman?
Much better, thank you.
As I was saying, it is no secret, we know that there have been federal congressional hearings on big tech as a monopoly in recent years. My work is primarily with state legislatures, and this is why I love legislation such as this, and we've been working on it because it does fit into the exemption clause of the federal statute. And it is my personal belief that as representatives of your constituents, you have so much more power and authority and the ability to make truly good decisions on what you think is best for your constituents and citizens of Maine. So this legislation does slide nicely into a state exemptions. It's a subsection E, subparagraph 3 for section 230 federally. And that is where we believe that the best starting point is to challenge these monopolies, these big tech monopolies, if you will. And opponents of this legislation would claim that this will become justiciable very quickly, and that big tech will then want to sue states and other things like this, in which that would go into a federal court hearing, which members of the Supreme Court have already spoken out against this and in favor of legislation like this, and challenging the question as to whether big tech does have truly a First Amendment right, as they are not a single actor, but rather like a bulletin board. So yes, in terms of taking on these very large corporations, where do we begin? That is the question. And that's why this legislation is very important, and why we are all here hopefully beginning to think and send the message to your constituents that this is important and this is something you care about.
Thank you for that response. It was helpful in helping me broaden my viewpoint on this. Thank you.
Thank you, Senator Keim, and thank you for your response, Ms. Fillmore. Are there additional questions for Ms. Fillmore? Seeing none, thank you very much. We greatly appreciate you taking the time and presenting your testimony to the Judiciary Committee on LD 1609 this afternoon. Thank you.
Chairman.
That exhausts the list of persons that I have registered to testify in any capacity on LD 1609. As I tend to do, I will check the attendee room one more time to ask if there's anybody who wants to be heard neither for nor against LD 1609. And seeing none, having heard all of the testimony presented by members of the public present today, I will close the public hearing on LD 1609. I thank the bill sponsor for bringing the bill forward to the Judiciary Committee, and thank you for your time today. I will now turn to